We are live.
Good afternoon, everyone, and welcome to, I think, a third part in a series from the ICJ rulings. This is Nazim from Palestine Solidarity Alliance. I'm glad today that Advocate Aslam Bava is with us again. We really value his input, especially his legal mind and how he unpacks things. I'm glad that our good friend from the Palestine Solidarity in Cape Town, Yusuf Chikte, PSC, Cape Town, is joining us as well. On the Zoom link, we have a number of people. We will give you an opportunity at the end of the program for people to share their thoughts and so forth. For now, it will just be the panelists, and I'm hoping also that Shiham Samai from the Women's Legal Center in Cape Town would also be joining us for the tail end of everything. For now, just to say that I think there's a lot of speculation, a lot of anticipation in terms of what to expect from the ICJ ruling. Aslam, welcome. Can you share with us what has been the thoughts, what is the feelings of different people across the board with regards to what to anticipate?
Yes, it has garnered a lot of discussion right across the legal fraternity, the political spectrum, and just community as such. The divide, in a sense, is whether the jurists will carry out their tasks as jurists and deliver a ruling that is in accordance with the law, or whether it will be something that is very politically motivated and determined by geopolitics. So this is currently a huge issue that is up for debate. I can also just unpack to you what the viewers can expect today in terms of the ruling and how it's going to unfold. So the ruling will be handed down by the president of the ICJ, which we know is President Joan Donoghue, and she will then read out the judgment to us. We will see her reading it out. In the Ukraine case, it took around about 33 minutes for her to read the entire judgment. And we know the Ukraine case was unopposed. There was no oral submission by Russia in that case. So there is a tremendous debate at all levels as far as today's ruling is concerned.
Thanks, Aslam. Obviously, we're hoping for at least some interim measures for a ceasefire. I think that is primary on everyone's mind. We cannot see the ongoing devastation, murder, bombing, and so forth. We are cognizant that as much as even in countries themselves, the judiciary and the executive and so forth need to be separated, politics always seem to play a part. So we are just hoping that at least some of those provisional measures go through, I think, to be realistic. But you never know. You never know what comes from it. It is just the most horrific and horrifying mass murder of civilian people that we've been witnessing over the 110 odd days. Yusuf, I'd like to go to you just to check with you. What is the sense of the political movement? Where to from this ruling, irrespective of the outcome?
Yeah, just before that, I think what has happened, irrespective of the outcome, is that the whole question of Palestine has been centralized. It is the whole world is looking at the issue around Palestine whereas before October the 7th, there was talks about normalization, ignoring the plight of the Palestinians and everything else. So in that sense, that focus of activity around and view about the necessity for a resolution on the Palestinian question and the right to self-determination has been brought centerfold in the whole debate. And where from here, irrespective of what the outcome is, already, we cannot rely on an international court and law alone to address and to resolve the 75-year-old settler colonial apartheid and a genocidal issue. We would have to, and at best, what one can expect is the court to fudge its findings, its verdict. And it is a political court, it is a divided court, and it has politicized its judgments before, more so when it comes to countries from the global south or settler colonial countries or former colonial countries where the injustices are perpetrated by the likes of Israel. Israel has already indicated that it wouldn't accept the verdict. It wouldn't implement it. It has garnered support from the United States, which has already said that the case is meritless and that it won't, and it will do everything in its power to block whatever the findings may be. But it is a finding that is that needs to be adhered to. But the enforceability is another question, and if it goes in terms of enforceability to the UN, it will definitely be, it's highly likely that it will be, at the Security Council, be vetoed by the United States and or the United Kingdom. So that is from here, but in as much as we cannot rely exclusively on international law, I mean, what has brought this case to the fore is the amazing international pressure for something to be done, for this not to be ignored. And that kind of pressure must continue irrespective of the extent or the degree of what the court agrees or disagrees with the recommendations of South Africa. Thank you.
Thank you, Prof. Chicktay. Aslam, back to you. Certainly, it is brought the world's attention. It's certainly thrown up a lot of debate within the legal circles as well. From here, obviously, if there is interim measures that are provided, where to? How does this get enforced? Should they call for a ceasefire?
Yes. So once the ICJ's ruling is made, it has to go to the Security Council for it to become enforceable against the state and against Israel. There, as Yusuf has indicated, there's going to be the exercise of the veto by the United States. And if Britain, the UK does what it normally does, it simply abstains, but you will have one veto in place. Once that occurs, then there is the Unity Accord, the Peace Accord, which allows a party that is disgruntled or a state that is disgruntled at the Security Council for not being able to exercise its right to refer it to the General Assembly. We know at the General Assembly it's by a simple majority and there is no veto. At the General Assembly, a number of things can happen. One is that Israel can be removed from all participation at the UN, which was done to South Africa when it practiced apartheid. The second element is that Palestine can be admitted as a member state to the UN. Currently, it's got observer status. And the third aspect is that sanctions can be imposed on Israel. There's already, if there's a ruling in favor of South Africa, there's a lot of pressure on those who are assisting and colluding in the genocide. So it will be of tremendous force. But as Yusuf says, irrespective of how it goes, the South Africans have made out a superb case from a legal perspective. Israel's defense was weak, and it relied on technical aspects of jurisdictional aspects. South Africa presented a prima facie case. So what we'll get is that we will find that the president will read out the judgment, and this will have been discussed by all the judges behind the scenes for the last 2 weeks. And from there, the final sense of the judgment will come out. I wonder if I could just run through the 15 different judges in the 15 different countries from which they come, so we can get a bit of a sense.
Please, Aslam, take us through that very quickly, and then we're just going to go quickly into some of those provisional measures.
Sure. So the president is Joan Donoghue, who's from the United States. The vice president is Kirill Gevorkyan from Russia. Then we've got Judge Peter Tomkov of Slovakia. The next one is Judge Ronnie Abraham from France. Judge Mohammed Benouna is from Morocco. Judge Abdul Kawi Ahmed Yusuf from Somalia. Judge Zui Hankin from China. Judge Julia Sebutinde from Uganda. Judge Dalvir Bandari from India. Judge Patrick Lipton Robinson from Jamaica. Judge Nawaf Salam from Lebanon. Judge Iwasawu Yuji from Japan. Judge George Nolter from Germany. Judge Hilary Charlesworth, Australia. And then Judge Leonard Nemer Caldera Brown from Brazil. And then we have two ad hoc judges. We know that is from South Africa, Judge Moseneke and Judge Aaron, not Aaron, I forgot his surname, but he's from Israel.
Thanks, Aslam. So we know that at the time of the presenting the case to the ICJ, there were already over 21,000 Palestinian civilians killed. An estimated 1,779 Palestinian families in Gaza had lost multiple members of their family. Over 311 doctors, nurses, and health workers, over 103 journalists, civil defense workers, 40, teachers and educational staff, 209, United Nations employees, 144 at the time. So those figures have grown significantly. And even as we speak now, we know that at the end of these proceedings, there'll be dozens more who have lost their lives, who have lost limbs, whose lives would forever be changed. There's nearly 2 million people who have been displaced. And the evidence for genocide is there. What we do also understand is that the court may not rule on whether this is genocide or not. What they may rule on is and make an order on is the provisional measures which South Africa has asked for. And I just want to take us through one or two of those provisional measures that South Africa has been asking for. The first, obviously, is that the state of Israel shall immediately suspend its military operation in and against Gaza. And I think this is something that we're all hopeful for, that the bombing must stop, the sniping, the mass murder needs to stop immediately. And then there are other interim measures like humanitarian aid, that there's investigations, that the evidence of genocide needs to be preserved and so forth. Yusuf, your thoughts on the interim measures, because those, I think, are foremost on everyone's mind.
Yeah. So just before that, the question, I mean, this is the outcome of the ICJ verdict today will reflect, it's an interim, it's an injunction. It's an interdictory order that they will provide. So the whole genocidal case still needs to unravel around that, as Aslam would be able to explain much better. So the conventions on which Israel, the recommendations that South Africa has made in terms of where it must stop, it's around the killing, the displacement, the infliction of disability on the Palestinian population, and so that is so compelling that it's going to be difficult to see how the court can avoid the contraventions of those clauses of what constitutes genocide against the Palestinians. So I think irrespective of what they do, I mean, it's already been decided on in the courtroom of public opinion that it's unacceptable. And what has taken place now, and Israel has committed these acts unabated, since despite them appearing in the dock at the Hague, and new words are emerging. I mean, the word genocide emerged in 1948, but these days people speak of genocide. You know, the killing of targeting of journalists, scholasticide, the deliberate killing and targeting of scholars and universities and educational institutions. So those charges have been compounded. I mean, we're familiar with epistemicide, you know, the killing of knowledge, but that done in such a short space of time is unprecedented. So there is mounting campaigns since the case has been launched around these aspects also. And I don't think this is going to go away irrespective of what the court decides. Thank you.
Thanks. Aslam, you rightfully pointed out and called out the names of those 15 judges, and there's speculation that if it's political, they'll follow their country's political ideologies and views. And that is obviously a worry. You've been in the judiciary. Is there pressure on, even at this highest level, politically, to follow suit?
Yeah, so this is an international space, and what it brings with it is a bit of a different flavor, because you have jurists who are principled jurists and want to rather see that the law is carried out, and irrespective of what their countries say. And we are hoping that there are many more of those than there are those who will follow what their countries say. We know Joan Donoghue has, in one case, dealing with the Mauritius case, 14 of the judges went one way, and because America didn't want it, she went the other way. So there is a bit of criticism about the president, whether she will still follow what the United States says. The term comes to an end in February. Each judge has 9 years, and their 9-year terms are coming. So the point is, what do they want to leave? And this is where the balance is. What do they want to leave as a legacy? As far as an institution that they have served for 9 years, do they want the integrity to be retained, or do they want it to be decimated?
Thank you, Aslam. We see the judges coming in. I'm just going to read one of the points in the provisional measures. This was summarized by one of the organizations. The State of Israel shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Palestinian people as a group protected by the Convention on the Prevention and Punishment of the Crime of Genocide, desist from the commission of any and all acts within the scope of Article 2 of the Convention, in particular, killing members of a group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and imposing measures intended to prevent births within the group. We know there is ample evidence that this is exactly what Israel is doing. We know that right now the starvation, the disease that's following from the lack of water, fuel, and food is critical. Thanks, Yusuf. We look forward then to hearing the order from the ICJ, and we'll deliberate
to deliver in
after.
open court its decision on the request for indication of provisional measures submitted by South Africa in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. Judge Robinson, who duly participated in both the deliberation and the final vote, is, for reasons made known to me, unable to take his seat on the bench today. I would like to welcome the eminent representatives of the Republic of South Africa and the State of Israel who are in the Great Hall of Justice today. In particular, I recognize the presence of Her Excellency, Ms. Naledi Pandor, Minister of International Relations and Cooperation of the Republic of South Africa. I recall that on 29 December 2023, South Africa filed in the registry of the court an application instituting proceedings against Israel concerning alleged violations in the Gaza Strip of obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, to which I shall refer as the Genocide Convention or the Convention. The application of South Africa contained a request for the indication of provisional measures submitted with reference to Article 41 of the statute and to Articles 73, 74, and 75 of the Rules of Court. In accordance with the usual practice, I shall not read the introductory paragraphs of the order which set out the procedural history of the case. I shall also omit or summarize some other paragraphs. I shall therefore begin the reading of the order at paragraph 13. In the order, the Court begins by recalling the immediate context in which the present case came before it. It observes that on 7 October 2023, Hamas and other armed groups present in the Gaza Strip carried out an attack in Israel, killing more than 1,200 persons, injuring thousands, and abducting some 240 people, many of whom continue to be held hostage. Following this attack, Israel launched a large-scale military operation in Gaza by land, air, and sea, which is causing massive civilian casualties, extensive destruction of civilian infrastructure, and the displacement of the overwhelming majority of the population in Gaza. The Court is acutely aware of the extent of the human tragedy that is unfolding in the region and is deeply concerned about the continuing loss of life and human suffering. The ongoing conflict in Gaza has been addressed in the framework of several organs and specialized agencies of the United Nations. In particular, reservations have been adopted by the General Assembly and the Security Council of the United Nations, referring to many aspects of the conflict. The scope of the present case submitted to the Court, however, is limited, as South Africa has instituted these proceedings under the Genocide Convention. The Court then turns to the conditions needed to be fulfilled in order for it to indicate provisional measures. With respect to the question of prima facie jurisdiction, the Court observes that it may indicate provisional measures only if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but it need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, South Africa seeks to found the jurisdiction of the Court on Article 36, Paragraph 1 of the Statute of the Court and on Article 9 of the Genocide Convention. The Court must therefore first determine whether those provisions prima facie confer upon it jurisdiction to rule on the merits of the case, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. Article 9 of the Genocide Convention provides, I quote, "Disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute." End of quote. South Africa and Israel are both parties to the Genocide Convention, and neither of them has entered a reservation to Article 9 or any other provision of the Convention. The Court then recalls that Article 9 of the Genocide Convention makes its jurisdiction conditional on the existence of a dispute relating to the interpretation, application, or fulfillment of the Convention. A dispute is a disagreement on a point of law or fact, a conflict of legal views or of interests between parties. In order for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. The two sides must hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. To determine whether a dispute exists in the present case, the Court cannot limit itself to noting that one of the parties maintains the Convention applies while the other denies it. Since South Africa has invoked as a basis for the Court's jurisdiction the compromissory clause of the Genocide Convention, the Court must also ascertain at the present stage of the proceedings whether it appears that the acts and omissions complained of by the applicant are capable of falling within the scope of that Convention, ratio materiae. The Court recalls that for purposes of deciding whether a dispute existed between the parties at the time of the filing of the application, it takes into account, in particular, any statements or documents exchanged between the parties, as well as any exchanges made in multilateral settings. In so doing, it pays special attention to the author of the statement or document, its intended or actual addressee, and its content. The existence of a dispute is a matter for objective determination by the court. It is a matter of substance, not a question of form or procedure. The court notes that South Africa issued public statements in various multilateral and bilateral settings in which it expressed its view that, in light of the nature, scope, and extent of Israel's military operations in Gaza, Israel's actions amounted to violations of its obligations under the Genocide Convention. For instance, at the resumed 10th Emergency Special Session of the United Nations General Assembly on 12 December 2023, at which Israel was represented, the South African representative to the United Nations stated that, I quote, "The events of the past 6 weeks in Gaza have illustrated that Israel is acting contrary to its obligations in terms of the Genocide Convention." End of quote. South Africa recalled this statement in its note verbal of 21 December 2023 to the Embassy of Israel in Pretoria. The court notes that Israel dismissed any accusation of genocide in the context of the conflict in Gaza in a document published by the Israeli Ministry of Foreign Affairs on 6 December 2023, which was subsequently updated and reproduced on the website of the Israel Defense Forces on 15 December 2023 under the title, "The War Against Hamas, Answering Your Most Pressing Questions," stating that, I quote, "The accusation of genocide against Israel is not only wholly unfounded as a matter of fact and law, it is morally repugnant," end of quote. In the document, Israel also stated that, I quote, "The accusation of genocide is not just legally and factually incoherent, it is obscene, and that there was no valid basis in fact or law for the outrageous charge of genocide," end of quote. In light of the foregoing, the court considers that the parties appear to hold clearly opposite views as to whether certain acts or omissions allegedly committed by Israel in Gaza amount to violations by the latter of its obligations under the Genocide Convention. The court finds that the aforementioned elements are sufficient at this stage to establish prima facie the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention. As to whether the acts and omissions complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention, the court recalls that South Africa considers Israel to be responsible for committing genocide in Gaza and for failing to prevent and punish genocidal acts. South Africa contends that Israel has also violated other obligations under the Genocide Convention, including those concerning conspiracy to commit genocide, direct and public incitement to genocide, attempted genocide, and complicity in genocide. At the present stage of the proceedings, the court is not required to ascertain whether any violations of Israel's obligations under the Genocide Convention have occurred. Such a finding could only be made by the court at the stage of the examination of the merits of the present case. At the stage of making an order on the request for an indication of provisional measures, the court's task is to establish whether the acts and omissions complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention. In the court's view, at least some of the acts and omissions alleged by South Africa to have been committed by Israel in Gaza appear to be capable of falling within the provisions of the Convention. In light of the following, the court concludes that, prima facie, it has jurisdiction pursuant to Article 9 of the Convention to entertain the case. Given this conclusion, the court considers that it cannot accede to Israel's request that the case be removed from the general list. The court turns next to the question of standing of South Africa. The court notes that the respondent did not challenge the standing of the applicant in the present proceedings. In the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia v. Myanmar, where Article 9 of the Genocide Convention was also invoked, the court observed that all states parties to the Convention have a common interest to ensure the prevention, suppression, and punishment of genocide. by committing themselves to fulfilling the obligations contained in the Convention. Such common interest implies that the obligations in question are owed by any state party to all the other state parties to the relevant convention. They are obligations erga omnes partes, in the sense that each state party has an interest in compliance with them in any given case. The common interest in compliance with the relevant obligations under the Genocide Convention entails that any state party, without distinction, is entitled to invoke the responsibility of another state party for an alleged breach of its obligations erga omnes partes. Accordingly, the Court found that any state party to the Genocide Convention may invoke the responsibility of another state party, including through the institution of proceedings before the Court, with a view to determining the alleged failure to comply with its obligations erga omnes partes under the Convention and to bringing a failure to the end. The Court concludes prima facie that South Africa has standing to submit to it the dispute with Israel concerning alleged violations of obligations under the Genocide Convention. The Court then turns to the question of the rights whose protection is sought and the link between such rights and the measures requested. It recalls that its power to indicate provisional measures under Article 41 of the statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the Court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the Court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. At this stage of the proceedings, however, the Court is not called upon to determine definitively whether the rights which South Africa wishes to seek protected exist. It need only decide whether the rights claimed by South Africa and for which it seeks protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. The Court recalls that in accordance with Article 1 of the Convention, all states parties thereto have undertaken to prevent and to punish the crime of genocide. Article 2 provides that, I quote, "Genocide means any of the following acts committed with an intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. A, killing members of the group. B, causing serious bodily or mental harm to members of the group. C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D, imposing measures intended to prevent births within the group. E, forcibly transferring children of the group to another group." End of quote. Pursuant to Article 3 of the Genocide Convention, the following acts are also prohibited by the Convention: conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. The provisions of the Convention are intended to protect the members of a national, ethnical, racial, or religious group from acts of genocide or any other punishable acts enumerated in Article 3. The Court considers that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on state parties thereto, and the right of any state party to seek compliance therewith by another state party. As the Court has stated in other cases, in order for acts to fall within the scope of Article 2 of the Convention, the intent must be to destroy at least a substantial part of a particular group. This is demanded by the very nature of the crime of genocide, since the object and purpose of the Convention as a whole is to prevent the intentional destruction of groups. The part targeted must be significant enough to have an impact on the group as a whole. The Palestinians appear to constitute a distinct national, ethnical, racial, or religious group, and hence a protected group within the meaning of Article 2 of the Genocide Convention. The Court observes that, according to United Nations sources, the Palestinian population in the Gaza Strip comprises over 2 million people. Palestinians in the Gaza Strip form a substantial part of the protected group. The court notes that the military operation being conducted by Israel following the attack of 7 October 2023 has resulted in a large number of deaths and injuries, as well as massive destruction of homes, the forcible displacement of the vast majority of the population, and extensive damage to civilian infrastructure. While figures relating to the Gaza Strip cannot be independently verified, recent information indicates that 25,700 Palestinians have been killed, over 63,000 injuries have been reported, over 360 housing units have been destroyed or partially damaged, and approximately 1.7 million persons have been internally displaced. The court takes note in this regard of the statement by the United Nations Undersecretary General for Humanitarian Affairs and Emergency Relief Coordinator, Mr. Martin Griffiths, on 5 January 2024. I quote, "Gaza has become a place of death and despair. Families are sleeping in the open as temperatures plummet. Areas where civilians were told to relocate for their safety have come under bombardment. Medical facilities are under relentless attack. A public health disaster is unfolding. Gaza has simply become uninhabitable. Its people are witnessing daily threats to their very existence while the world watches on." End of quote. Following a mission to North Gaza, the World Health Organization reported that as of 21 December 2023, I quote, "an unprecedented 93% of the population of Gaza is facing crisis levels of hunger, with insufficient food and high levels of malnutrition." End of quote. The court further notes the statement issued by the Commissioner General of the United Nations Relief and Works Agency for Palestine refugees in the Near East, or UNRWA, Mr. Philippe Lazzarini, on 13 January 2024. I quote, "It's been 100 days since the devastating war started, killing and displacing people in Gaza following the horrific attacks that Hamas and other groups carried out against people in Israel. It's been 100 days of ordeal and anxiety for hostages and their families. In the past 100 days, sustained bombardment across the Gaza Strip caused the massive displacement of a population that is in a state of flux, constantly uprooted and forced to leave overnight, only to move to places which are just as unsafe. This war affected more than 2 million people, the entire population of Gaza. Many will carry lifelong scars, both physical and psychological. The vast majority, including children, are deeply traumatized. Overcrowded and unsanitary UNRWA shelters have become home to more than 1.4 million people. They lack everything, from food to hygiene to privacy. People live in inhumane conditions where diseases are spreading, including among children. They live through the unlivable with the clock ticking fast towards famine. The plight of children in Gaza is especially heartbreaking. An entire generation of children is traumatized and will take years to heal. Thousands have been killed, maimed, and orphaned. Hundreds of thousands are deprived of education. Their future is in jeopardy with far-reaching and long-lasting consequences. The UNRWA Commissioner General also stated that the crisis in Gaza is, I quote, "compounded by dehumanizing language," end of quote. In this regard, the court has taken note of a number of statements made by senior Israeli officials. It calls attention in particular to the following examples. On 9 October 2023, Mr. Yoav Gallant, Defense Minister of Israel, announced that he had ordered a complete siege of Gaza City, and that there would be no electricity, no food, no fuel, and that everything was closed. On the following day, Minister Gallant stated, speaking to Israeli troops on the Gaza border, I quote, "I have released all restraints. You saw what we are fighting against. We are fighting human animals. This is the ISIS of Gaza. This is what we are fighting against. Gaza won't return to what it was before. There will be no Hamas. We will eliminate everything. If it doesn't take one day, it will take a week, it will take weeks or even months. We will reach all places." End of quote. On 12 October 2023, Mr. Isaac Herzog, President of Israel, stated, referring to Gaza, I quote, "We are working, operating militarily according to rules of international law, unequivocally. It is an entire nation out there that is responsible. It is not true, this rhetoric about civilians not aware, not involved. It is absolutely not true. They could have risen up. They could have fought against that evil regime which took over Gaza in a coup d'etat. But we are at war. We are at war. We are at war. We are defending our homes. We are protecting our homes. That's the truth. And when a nation protects its home, it fights. And we will fight until we break their backbone." End of quote. On 13 October 2023, Mr. Israel Katz, then Minister of Energy and Infrastructure of Israel, stated on X, formerly Twitter, I quote, "We will fight the terrorist organization Hamas and destroy it. All the civilian population in Gaza is ordered to leave immediately. We will win. They will not receive a drop of water or a single battery until they leave the world." End of quote. The court also takes note of a press release of 16 November 2023 issued by 37 special rapporteurs, independent experts, and members of working groups part of the special procedures of the United Nations Human Rights Council, in which they voiced alarm over, I quote, "discernibly genocidal and dehumanizing rhetoric coming from senior Israeli government officials." End of quote. In addition, on 27 October 2023, the United Nations Committee on the Elimination of Racial Discrimination observed that it was highly concerned about the sharp increase in racist hate speech and dehumanization directed at Palestinians since 7 October. In the court's view, the aforementioned facts and circumstances are sufficient to conclude that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. This is the case with respect to the right of Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. The court then turns to the condition of the link between the plausible rights claimed by South Africa and the provisional measures requested. It considers that by their very nature, at least some of the provisional measures sought by South Africa are aimed at preserving the plausible rights it asserts on the basis of the Genocide Convention in the present case, namely, the right of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts mentioned in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. Therefore, a link exists between the rights claimed by South Africa that the court has found to be plausible and at least some of the provisional measures requested. The court turns next to the question of risk of irreparable prejudice and urgency. It notes that, pursuant to Article 41 of its statute, it has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are the subject of judicial proceedings, or when the alleged disregard of such rights might entail irreparable consequences. However, the power of the court to indicate provisional measures will only be exercised if there is urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the court gives its final decisions. The condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the court makes the final decision in the case. The court must therefore consider whether such a risk exists at this stage of the proceedings. The court is not called upon for purposes of its decision on the request for the indication of provisional measures to establish the existence of breaches of obligations under the Genocide Convention, but to determine whether the circumstances require the indication of provisional measures for the protection of rights under that instrument. As already noted, the Court cannot at this stage make definitive findings of fact, and the right of each party to submit arguments with respect to the merits remains unaffected by the Court's decision on the request for the indication of provisional measures. The Court recalls that, as underlined in General Assembly Resolution 96-1 of 11 December 1946, I quote, "Genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these human groups, and is contrary to moral law and to the spirit and aims of the United Nations." End of quote. In view of the fundamental values sought to be protected by the Genocide Convention, the Court considers that the plausible rights in question in this proceeding, namely, the right of Palestinians in the Gaza Strip to be protected from acts of genocide and related prohibited acts identified in Article 3 of the Genocide Convention, and the right of South Africa to seek Israel's compliance with the latter's obligation under the Convention, are of such a nature that prejudice to them is capable of causing irreparable harm. During the ongoing conflict, senior United Nations officials have repeatedly called attention to the risk of further deterioration of conditions in the Gaza Strip. The Court takes note, for instance, of the letter dated 6 December 2023, whereby the Secretary General of the United Nations brought the following information to the attention of the Security Council. I quote, "The healthcare system in Gaza is collapsing. Nowhere is safe in Gaza. Amid constant bombarding by the Israel Defense Forces and without shelter or the essentials to survive, I expect public order to completely break down soon due to the desperate conditions rendering even limited humanitarian assistance impossible. An even worse situation could unfold, including epidemic diseases and increased pressure for mass displacement into neighboring countries. We are facing a severe risk of collapse of the humanitarian system. The situation is fast deteriorating into a catastrophe with potentially irreversible implications for Palestinians as a whole and for peace and security in the region. Such an outcome must be avoided at all costs." End of quote. On 5 January 2024, the Secretary General wrote again to the Security Council, providing an update on the situation in the Gaza Strip and observing that, I quote, "Sadly, devastating levels of death and destruction continue." End of quote. The Court also takes note of the 17 January 2024 statement issued by the UNRWA Commissioner General upon return from his 4th visit to the Gaza Strip since the beginning of the current conflict in Gaza. I quote, "Every time I visit Gaza, I witness how people have sunk further into despair, with the struggle for survival consuming every hour." End of quote. The Court considers that the civilian population in the Gaza Strip remains extremely vulnerable. It recalls that the military operation conducted by Israel after 7 October 2023 has resulted inter alia in tens of thousands of deaths and injuries and the destruction of homes, schools, medical facilities, and other vital infrastructure, as well as displacement on a massive scale. The Court notes that the operation is ongoing and that the Prime Minister of Israel announced on 18 January 2024 that the war, I quote, "will take many more long months." End of quote. At present, many Palestinians in the Gaza Strip have no access to the most basic foodstuffs, potable water, electricity, essential medicines, or heating. The World Health Organization has estimated that 15% of the women giving birth in Gaza Strip are likely to experience complications, and indicates that maternal and newborn death rates are expected to increase due to the lack of access to medical care. In these circumstances, the Court considers that the catastrophic humanitarian situation in the Gaza Strip is at serious risk of deteriorating further before the Court renders its final judgment. The Court recalls Israel's statement that it has taken certain steps to address and alleviate the conditions faced by the population in the Gaza Strip. The Court further notes that the Attorney General of Israel recently stated that a call for intentional harm to civilians may amount to a criminal offense, including that of incitement, and that several such cases are being examined by Israeli law enforcement authorities. While such steps are to be encouraged, they are insufficient to remove the risk that irreparable prejudice will be caused before the Court issues its final decision in the case. In light of the foregoing, the Court considers that there is urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights found by the Court to be plausible before it gives its final decision. The Court concludes, on the basis of the aforementioned considerations, that the conditions required by its statute for it to indicate provisional measures are met. It is therefore necessary, pending its final decision, for the Court to indicate certain measures in order to protect the rights claimed by South Africa that the Court has found to be plausible. The Court recalls that it has the power under its statute, when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. In the present case, having considered the terms of the provisional measures requested by South Africa and the circumstances of the case, the Court finds that the measures indicated need not be identical to those requested. The Court considers that, with regard to the present situation, Israel must, in accordance with its obligations under the Genocide Convention, in relation to Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. The Court recalls that these acts fall within the scope of Article 2 of the Convention when they are committed with the intent to destroy in whole or in part the group as such. The Court further considers that Israel must ensure with immediate effect that its military forces do not commit any of the aforementioned acts. The Court is also of the view that Israel must take measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to the members of the Palestinian group in the Gaza Strip. The Court further considers that Israel must take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. Israel must also take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Genocide Convention against members of the Palestinian group in the Gaza Strip. Regarding the provisional measure requested by South Africa that Israel must submit a report to the Court on all measures taken to give effect to the order, the Court recalls that it has the power, reflected in Article 78 of the Rules of Court, to request the parties to provide information on any matter connected with the implementation of any provisional measures it has indicated. In view of the specific provisional measures it has decided to indicate, the Court considers that Israel must submit a report to the Court on all measures taken to give effect to this order within 1 month as from the date of this order. The report so provided shall then be communicated to South Africa, which shall be given the opportunity to submit to the Court its comments thereon. The Court recalls that its orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The Court reaffirms that the decision given in the present proceedings in no way prejudges the question of the jurisdiction of the court to deal with the merits of the case, or any questions related to the admissibility of the application or to the merits themselves. It leaves unaffected the right of the governments of the Republic of South Africa and the State of Israel to submit arguments in respect of these questions. The order then states that the court deems it necessary to emphasize that all parties to the conflict in the Gaza Strip are bound by international humanitarian law. It is gravely concerned about the fate of the hostages abducted during the attack in Israel on 7 October 2023 and held since then by Hamas and other armed groups, and calls for their immediate and unconditional release. I shall now read out the operative part of the order. For these reasons, the Court indicates the following provisional measures. 1. By 15 votes to 2, the State of Israel shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 15 votes to 2, the State of Israel shall ensure, with immediate effect, that its military does not commit any acts described in point 1 above. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 16 votes to 1, the State of Israel shall take all measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to members of the Palestinian group in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judges Ad hoc Barak, Moseneke. Against, Judge Sebatinde. By 16 votes to 1, the State of Israel shall take immediate and effective measures to ensure the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judges Ad hoc Barak, Moseneke. Against, Judge Sebatinde. By 15 votes to 2, the State of Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Convention on the Prevention and Punishment of the Crime of Genocide against members of the Palestinian group in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 15 votes to 2, the State of Israel shall submit a report to the Court on all measures taken to give effect to this order within 1 month as from the date of the order. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebutinde, Judge Ad hoc Barak. I shall now call upon the registrar to read the operative part of the order in French.
Par ces motifs, la Cour indique les mesures conservatoires suivantes. 1. Par 15 voix contre 2, l'État d'Israël doit, conformément aux obligations lui incombant au titre de la Convention pour la prévention et la répression du crime de génocide, prendre toutes les mesures en son pouvoir pour prévenir la commission, à l'encontre des Palestiniens de Gaza, de tout acte entrant dans le champ d'application de l'article 2 de la Convention, en particulier les actes suivants. A. Meurtre de membres du groupe. B. Atteinte grave à l'intégrité physique ou mentale de membres du groupe. C. Soumission intentionnelle du groupe à des conditions d'existence devant entraîner sa destruction physique totale ou partielle. Et D. Mesures visant à entraver les naissances au sein du groupe. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 2. Par 15 voix contre 2, l'État d'Israël doit veiller avec effet immédiat à ce que son armée ne commette aucun des actes visés au point 1 ci-dessus. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 3. Par 16 voix contre 1, l'État d'Israël doit prendre toutes les mesures en son pouvoir pour prévenir et punir l'incitation directe et publique à commettre le génocide à l'encontre des membres du groupe des Palestiniens de la bande de Gaza. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Messieurs Barak, Moseneke, juge ad hoc, contre Madame Sebutinde, juge. 4. Par 16 voix contre 1, l'État d'Israël doit prendre sans délai des mesures effectives pour permettre la fourniture des services de base et de l'aide humanitaire requis de toute urgence afin de remédier aux difficiles conditions d'existence auxquelles sont soumis les Palestiniens de la bande de Gaza. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Messieurs Barak, Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge. 5. Par 15 voix contre 2, l'État d'Israël doit prendre des mesures effectives pour prévenir la destruction et assurer la conservation des éléments de preuve relatifs aux allégations d'actes entrant dans le champ d'application des articles 2 et 3 de la Convention pour la prévention et la répression du crime de génocide commis contre les membres du groupe des Palestiniens de la bande de Gaza. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc, contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 6. Par 15 voix contre 2, l'État d'Israël doit soumettre à la Cour un rapport sur l'ensemble des mesures qu'il aura prises pour donner effet à la présente ordonnance dans un délai d'1 mois à compter de la date de celle-ci. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolt, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc.
Judge Shui appends a declaration to the order of the court. Judge Sebutinde appends a dissenting opinion to the order of the court. Judges Bandari and Nolta append declarations to the order of the court. Judge Ad hoc Barak appends a separate opinion to the order of the court. The text of the court will be available from today in typescript. It will be available shortly on the court's website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.
Nothing can come on.
Can you hear me? You need to, you're blocking me from getting video. Hi, everyone. Thank you. I think, well, firstly, within the hour, as predicted, they would make this ruling. We're just trying to gather our thoughts together and see what are the provisions that were accepted or supported, and then obviously the silence on the ones that were not supported, which we will get through a little bit later. What we're going to do now is we're going to try and just link up with our panelists and just to see if everyone is on board already as we get back into the discussion. I think critical for me was the fact that we saw lots of reference to UN reports and statements from people on the ground in Gaza in terms of what they've witnessed and experienced, and that played a significant part, I think, in the ruling. I'm just going to get quick feed opinions on what's happening. Advocate Bava, Aslam, your thoughts, quickly.
Well, to me, as a lawyer, this is a momentous day. I mean, to the Palestinian struggle as well. And we saw one party, Sebutinde from Uganda, that seemed to have followed the political line of the Zionists in Israel. Apart from that, we've had independent jurists expressing their views and towards what is clearly an injustice being perpetrated against the Palestinians. The decision, the order of genocide cannot be made at this stage because it is an interim order pending a determination of genocide. But what it is, and the measures, the interim measures that have been put into place are phenomenal. We need to study them a bit closer as well. But I think it's an absolute victory for the Palestinian people, for the South Africans who brought the case, and I think for the world at large.
Thank you. Youssouf, your thoughts?
Yeah, I think I must say that I'm elated. It's much more than what I expected from an international court. And I feel vindicated as a South African and with South Africa having brought the case. And I think we need to celebrate an important milestone in holding Israel accountable and stopping its impunity. So that's, and what the court said, that we have jurisdiction, that it's plausible what we are saying, that there is an urgency and that we need to act upon it. And the ones that I ticked off and Aslam will do it much better. It's the disappointing part, and this is where the fudging comes in, is the question of a ceasefire, the stopping of military activity, immediate stopping of military activity and those measures. But point 4, the ones that you've read out in accordance with its obligations to stop killing, causing serious bodily harm, deliberately inflicting conditions of life which are unbearable, imposing measures to intend to stop births. That one is, and not to destroy the evidence, in short, to report regularly, and that is the accountability that is taking place, that the court emphasized that it is binding, and that they must stop the incitement. So we got that, and the others, I think we need now to pursue and embark upon and continue with our protest as we get that. But my immediate reaction is it's a victory, it's a vindication, and how do we go from here?
Thanks. I think it's much more than I anticipated. I will not lie. I thought they'd try and obfuscate with some sort of technicality on jurisdiction and this and that. They've covered, I think, the bases well. Aslam is our legal expert there. We're going to spend a little time with him to unpack this for the lay people out there to understand exactly what this ruling is. And then we're going to unpack a little bit what does it mean and where to from here. So just to give you guys the heads up, we've got about 45 minutes to get through all of this. There were 4 orders, Aslam, that were brought out. The first 4, was it 4 or was it 5? 6 orders. Are we going to go through them? Let's go through them. That Israel shall take all measures to prevent all acts of genocide, Article 2, right? That is killing people in a group, harming people, creating conditions of life that make leads to physical destruction in whole or part, and the prevention of birth. So there is a direct call that Israel has to take all measures to prevent all acts of genocide as contained in Article 2. Is that a straightforward call? Is that a call for them to stop what they're doing?
I think it's pretty broad. Taking into account Article 2, I mean, Article 2 has got 5 different elements to it. And the first one is killing members of the group. So they've been killing Palestinians. So to stop killing Palestinians. The second one is causing serious bodily or mental harm to members of the group. And that too is, Israel has been, I mean, even for children, what it does is it goes past and it drops what it calls sound bombs, just to scare the children and to scare people. So it's, and the continuous mental harm and bodily harm. So that is quite broad as well. Then C is deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. So that call by the Israeli army, by Gallant, where he said we will no longer give them food, water, any access to all of that, that has to stop. Imposing measures intended to prevent births within the group. We know that births have been reduced by up to 30% during this time, and where they are giving births, they're giving births in circumstances where there is no proper hospital facilities and there are no anesthetics and any of those things available to Palestinians. And then E, forcibly transferring children of the group to another group. And this was an intention that Israel wanted to transfer the entire Palestinian population into Egypt or into the Sinai desert. And this is going to be stopped. So to me, that is, following Article 2, that is a huge victory. It's that it's broad enough to cover almost everything that they're doing.
Yeah, we realized, I mean, this is the essence of what has made South Africa to bring this case forward to the ICJ, because these things are happening. This was the intent of the Israelis. We go on to the second order, which was that, and I paraphrase just my little shorthand, I caught some of it, so you can correct me, that Israel shall ensure that its military does not commit any of these acts of genocide.
Yes. So the first one would be, on the first one would be the types of acts that cannot be committed. And the second one is the actors who commit it. So it would, if you didn't draw the link, if the court didn't draw the link and say, you don't commit all these acts in terms of Article 2 on their own, they could have found an excuse and say, but you didn't say who mustn't commit it. So now what it does is it says the Israeli army specifically will not commit these acts.
Great. Yusuf, you can also come in here. I don't know if Shiham is with us. The issue, the order number 3, and this was 16-1. It's only the Ugandan that didn't support it. It's the prevention and punishment of incitement to commit genocide. I thought this was significant. I think we don't even need now a ruling. This tells you that there is genocide and incitement for genocide. Because why make an interim order to say, stop this, prevent it and punish it?
Yes, so let's understand that, firstly, the court hasn't made a ruling on genocide.
Right.
And it was very clear that it's saying we will not make this ruling and do not interpret any provision or any relief that we are granting here to constitute a determination of the final aspect of genocide. What it is saying in terms of the Genocide Convention, every country who is a member to the Genocide Convention has to pass rules nationally to punish the crime of genocide. So what they are saying is that you, Israel, have not done this. If your soldiers are acting in a genocidal manner, you need to bring them to book. So it is not saying that we have determined that there is genocide, but if you now have a duty over your soldiers and anybody in your country that carries out these genocidal acts to have national legislation enacted and to ensure that they do not commit this crime.
Before I go into the next few orders that were made, Yusuf, your thoughts, Israel and compliance to this order, what do you think? What's the likelihood?
They've clearly stated that they won't accept it. Netanyahu said that. The other ministers have also said that. And there is going to be a great deal of obfuscation around this and contestation around this. And I think it requires the continuation of international pressure on our own governments and internationally and on international governments to ensure that Israel becomes accountable for what the interim order is about. And we must also raise the issue of complicity of those who acquiesce or support Israel in this measure. And it opens up the doorway for other kinds of sanctions at the United Nations, calling in the Convention Against Apartheid, and other domestic measures which we must now embark upon. I think we must mount the pressure. There's 1 month in which they must report. We must monitor what they're doing and look at the next steps, failing them not adhering to enforcing what has been decreed. Thank you.
Thank you.
Sorry, can I just go back to our recommendations 1 and 2? Mm-hmm. Was there a clear directive from the court on that? The fact that they must suspend its military operations. The state shall ensure that military or irregular army units may be directed, supported, to influence. That one of first two. I couldn't get that.
There was silence on it.
There was silence.
They didn't speak to it.
Yeah, they didn't speak to it. Aslam?
Aslam?
Yeah, I didn't hear that they spoke. And what the President Donahue said is that we're going to adapt it. So what they've done is they indicated right from the beginning that while South Africa meets all of the requirements, it doesn't mean that all the relief that South Africa is seeking will be given in the terms that they sought. That what the court, the International Court of Justice, did is that it crafted the order in a way that it saw would facilitate a situation where this killing of the Palestinians, the displacement of the Palestinians, and the prevention of food aid and all of those things would be prevented by way of the order that they have given. So the wording is different and the implications are different. One needs to study the wording closer to be able to, because it was, I don't know with you, but it was difficult to keep up with those orders but we need to go back,
Yeah.
which they said they've downloaded. I've been trying to get it on the ICJ website just to read it while we were here. But I think the sense is that they haven't given the full order, and they've combined orders. They've taken maybe 1 and 3 and combined those.
But I think that the first point of relief that South Africa had asked for, and then the second point was an extension of that. The first point was that Israel's military would suspend all operations in and against Gaza. So there wasn't a clear, unequivocal kind of order to say Israel needs to suspend it. But there is this provision that Israel has to prevent all these acts of genocide. I'm going to go on to the other one, and this one is a bit tricky for me. You guys may need to unpack that for me. It says that Israel is to oversee immediately humanitarian services. How is the perpetrator responsible for the well-being of its victim?
Well, from my sense is that, remember, they control the Rafah border, and they prevent food aid from coming in and medical supplies, medical aid. So I think what the order is telling them is that, look, you have a responsibility to ensure that it is facilitated, not that you are preventing it and not being prevented. So it's a very indirect order. I have no doubt that the Israelis will try and find every way to misinterpret or to interpret it in a way that's going to benefit them. I mean, that including the later order where they say all the hostages must be released by Hamas unconditionally, meaning that the prison swap with Israel holding over 8,000 prisoners, that is problematic because they've used the word unconditionally. And so that is a problematic statement, because Hamas's stated aim was that you are imprisoning Palestinians, on administrative detentions without trial and unjustly. And now the court has ordered that that the hostages must be released unconditionally. So that needs to be looked at closer as well.
Yeah, certainly. Yusuf, come in.
Yeah, well, I agree with Aslam. I mean, we need to study this further. But Aslam, the access to humanitarian aid and lifting of restriction on it, there are about 7 entry points into Gaza. And the Rafah border is actually legally under the control of Egypt. Yet Egypt is awaiting orders from Israel or working in cahoots with Israel in opening it up. So the whole question around complicity of Egypt in preventing the passage of humanitarian aid is something that needs to be considered as well. The complicity of other governments, and in this case particularly the complicity of Egypt in blocking and preventing and seeking permission from Israel for the free flow of humanitarian aid. I just wanted to flag that point.
No,
Yusuf, you raise a very interesting point, because now what that means is that Egypt is now told that if you, very indirectly, actually this order tells the world, any of you who are going to be assisting and aiding and abetting this genocide, just be careful. So Egypt must now be called to book. We know that Egypt has worked very closely with Israel as far as this is concerned. But they are also on the ground, there's a swelling against the population, against the government. So what we're going to see is a very interesting twist, because what we must see, the buoyancy of what this has created in the world, is that those who had doubts, those doubts have been removed. Those who thought that justice will not be served at any level because it's a United Nations entity, are now looking at it differently and saying justice can be served. So it's going to spur on the fight for and the movement towards justice in Palestine.
I have no doubt about that. I think that this is a tipping point, a pivotal moment in the struggle, in the broader anti-colonial struggle, because a lot of this is a shifting, and you're seeing former colonized people standing firmly with South Africa. Not all, but many. What Yusuf also raises is, and this one I needed to ask you even before we got to today, is this ruling and its implications for those people or those nations, those individuals that support Israel. What is the implications for those in terms of a genocidal ruling? Obviously, that's not been made yet, but certainly there is now pressure on the United States, on Egypt, on those states that embolden Germany, Israel to relook at their positioning.
Yes, I think you'll note that if you look at the United States Congress, if you look at the UK Parliament, and if you look at the debates that are going on there, this is tipping the scales, because Sunak can't get away with giving his excuses by saying it's too complicated and things need to be considered further. Biden and Blinken are going to be under tremendous pressure, because within the Democrats, there is now a huge movement towards supporting the human rights of Palestinians. So just on an international scale with different countries, the internal aspect is going to, I think, explode. And we're also going to see that any person who is seen as supporting Israel will be seen to be violating the ICJ ruling.
Thank you. We've got two more things. One in the order that I just jotted down. One is that Israel is instructed to prevent the destruction of evidence of the crimes of genocide. I think straightforward, it was one of the orders that South Africa had asked for. But the important one is that they need to report within 1 month on how they have brought effect to the orders listed above. So the orders of prevention of genocide, stopping their military from committing acts, stopping and punishing those people inciting for genocide. Within a month, Israel has to give a report. What happens if between now and that report, are we still stuck in this continuous murderous state that we're seeing unfolding in Gaza?
Yeah. My view is that as with immediately after the 7th of October and the ceasefire and the court at those intervals when the accusation was made in January, Israel mounted a massive campaign to continue with the genocidal activities that it has been conducted. And I think during the interim period, Israel is going to wreak havoc yet again, mindlessly on the Palestinian people. And it's going to harp on the fact that the refugees, it's going to shift the attention to the release of the refugees, for that to be unconditionally released.
The hostages.
The hostages, my apologies, to be released. And so there's going to be a great deal of obfuscation. But from our side, stop, the war must stop, the ceasefire must be declared, the occupation must stop, settler colonialism must stop, and Israel must get out of Palestine.
Aslam,
I think that's the demands that we need to make as we go along.
Thanks, Yusuf. Aslam?
Yes, so
1 month story.
In the case of Myanmar and in the case of Ukraine, the court made similar orders. So what needed to happen and what needs to happen is the conduct that Israel is bound by is immediate. So it does not have to wait for a report to be produced within a month or for it to comply. What Israel has to come back to the court and do is that it needs to come and tell the court what it has been doing in order to comply with the court order. So the court can assess it and tell Israel after a month, but you've come back with this report, you're still not giving this, you're still not giving that. I don't know if you noticed in the judgment, on the ruling, when the judge was giving it, the President Donahue, she mentioned an incident on the 13th of January. There was a report published on the 13th of January. That was after the oral hearing.
Mm-hmm.
And she also looked at and read out from a report on the 5th of January. Now, all of that was after South Africa had submitted its written complaint. But so it's interesting that the ICJ was continuously monitoring what was happening and took that into account in making this order. You remember the ICJ order is not appealable. So an ICC judgment is appealable, but an ICJ order is final and binding.
So from my, and really, I think that was significant. I think she quoted, and I was impressed with that. That blew me. I mean, statements that I wouldn't think they would want in the record from the United Nations Special Rapporteur for UNRWA, from the Secretary General, all of it, even using terms like this is a genocide and so forth. I think the court also explained that they had a difficulty, or they had a duty to show that there was a violation of rights, and then link that to the provisional measures. So there needed to be a plausible case of rights violation. And I think that for me, those quotations were used in that context to elicit that there is just definitely a clear case that Palestinian rights are being violated. And therefore, this ruling, it's a brilliant ruling. I think far more than what I anticipated. And from here, I think Yusuf's outlined what we in civil society need to be doing to take forward the struggle, because there is still the occupation of Palestine. There is still the continuous, the apartheid system that is in place, the illegal occupation, the detentions without trials, or the murder, the assassinations, the restrictions on movement, the violation of religious rights. These are ongoing struggles, but we've reached a tipping point. And for me, that tipping point, firstly, what October 7th has done, it has brought Palestine to the center force of the world. It has also cleared the lines between those who stand with human rights and human values and those who support a very narrow racist ideology of Zionism and racism in that sense. So we've now reached this pivotal point. The next point, I think, is that the UN, particularly the Security Council, and South Africa may take this to the Security Council for enforcement. If Israel's not going to comply. The arrogance has demonstrated that this will need to be enforced. What are your guys' thoughts? Would the UN be able to enforce some sort of prevention on the acts of genocide?
Aslam, can I go first and then you come back, because you can. So I think that we know Israel's impunity and their threats not to obey those things. If after the first month we don't have any relief in what is taking place, and then then the enforceability comes about at a different agency like the UN. But then it opens up that whole door to kick Israel out of the United Nations. That becomes a prospect like what happened to South Africa a couple of years ago. So the pressure that we must mount is precisely that. Operate at all these different multilateral agencies. The pressure on the ICC now also increases to do something about it. And I think that is going to be an important one to catalyze. This decision catalyzes the speed with which they need to act with the several cases that they have at hand. And it will shame them even more if they don't do anything. The UN convention that we have in mind, the Apartheid Convention that we have in mind in May, to declare Israel an apartheid state at the UN, that becomes a more compelling case for us to do. We cannot rely on this case alone in prosecuting our goals for a free, undivided, equal a Palestine which stands for equality, justice, and freedom. Thank you.
Thank you, Yusuf. Aslam, and then after that, we're going to just open to the Zoom link floor for comment. Aslam?
Yes, so just one thing that Yusuf spoke about earlier, just when we started talking, from a legal perspective, I just want to mention that all the arguments raised by Israel, which were technical arguments, were dismissed.
Oh, brilliant.
So the legal argument on the locus standi of South Africa was dismissed. The Myanmar case and Gambia versus Myanmar case dealt with that. The jurisdiction of the ICJ to hear this matter, and that South Africa was not actually the victim, that too was dismissed. The urgency that South Africa asked for was upheld, and Israel argued against and said there was no urgency in the matter. Well, one can't understand how one can even say that. And then the prima facie case was also upheld, and furthermore, the link to the relief. So what we term in South Africa causation. What caused are all these acts that South Africa is complaining, do they link up to the relief that you are seeking? And the court held in favor of South Africa. So basically, any and every argument that Israel had brought up was dismissed.
Yeah, thanks, Islam. I think that is pretty significant. We'll now obviously continue with our solidarity work. We've got, I think, for Sunday, a very significant program nationally in South Africa in different centers. Look out for the post. We will be commemorating the press deaths of people in Gaza, particularly the press, and we're looking to also then use that platform to further unpack some of the outcomes of this ICJ ruling. It's really been, I think, a very positive ruling, much more than we anticipated. It's now to see how it rolls out and impacts directly on the situation on the ground. I'm not too sure if anyone from the audience in the Zoom link wants to say anything. You can just unmute and bring them in. Is there anyone who wants to make a comment? Right. Okay. So it doesn't look like it. So thank you very much. We're going to.
I just want to say one last thing.
Comment, yeah.
I just want to make one last comment, and this is for Islam, that the court redeemed itself in the eyes of the world. That we can still seek recourse in these matters, and I think it must be acknowledged in as much as our vindication, we feel vindicated about bringing it to the court, and I think that trust in a system is very important to hold our society together. Islam, that was your line actually.
Yes, Yusuf, that's why I opened by saying as a lawyer today, I'm very happy that the law has triumphed over oppression. And we're hoping that this will be, as Nazim has stated, the way forward into building more on this and creating, a sustainable human rights future.
Thank you very much, everyone. Aslam, it's been a fantastic couple of hours listening initially to South Africa's team, the A team. They were brilliant, every one of them. We know how much they are loved. We saw when they were welcomed at OR Tambo as if they were a winning national soccer team. That's how much South Africans cherished and appreciated them. The same appreciation goes from the Palestinian people to the South African people, our leadership. There's much wrong in our country, but I think this one they got right. I think here South Africa took a very bold and brave step. Where others were coward, the South Africans took a principled position, and we took this thing to the ICJ. We've got, I think, vindicated, as Yusuf said. I said at a speech at Sandton at the U.S. Embassy that the ICJ was on trial now. that we were waiting for them, and I think they've come out. It's clear that the pariah status that we imposed on apartheid South Africa is now firmly attached to apartheid Israel, and we need to now push further until we see the end of that colonial state and the liberation of the Palestinian people. We all need to redouble our efforts now. It's not yet a victory. Victory, we know, is not in our hands, but when it is steps towards that ultimate victory. And I want to thank everyone.
It's a win, not a victory. It's a win.
It's a win,
but not a victory yet.
No, victory is soon. And I think everyone is anticipating now a greater optimism. The difficulty is that we know that there are people still suffering. We know that there are people still dying. There are still people in prison. Let us continue our efforts. Let's redouble our efforts. And just to say, as I'm speaking now, Aslam, I'm just getting text message after text message that they want to have a public forum where we unpack this further, but also invite our minister and some of the A team and celebrate them for the efforts. I think it's important that we as South Africans, with our Palestinian friends and partners in South Africa, host a massive support rally for our team and for what South Africa has done, and use that as an impetus to drive further the end of apartheid Israel. I thank you everyone for joining us today. Please keep in touch. Follow us. There's PSC Cape Town, Yusuf, Chikte, Prof. Well done. Aslam Bava for your valuable input. Ahmed from Suk Islam for all of your technical support. Firoza at the back as well. All the PSA team in South Africa. And we know that you're in a building space as well. So good luck to that, for the PSA for this weekend. All the best to everyone. Let's keep in touch. Let's keep the momentum with the international solidarity. Amandla Intifada. Amandla.
Thank you.
Thank you.
Aslam, bye-bye, and thanks to everybody.
Bye, Yusuf.
Bye-bye, everyone.
Bye-bye. Thanks, Nazim. Thanks, Firoza.
Assalamu alaikum.
Thanks,
See
all of you.
everyone.
Walaikum salam.
Okay, we off.